Welcome to our panel on the web as a battleground of free expression. My name is Garrett Epps. I am professor of law at the University of Baltimore, and I cover the Supreme Court for theatlantic.com. I'm glad to have you here. I'm looking forward to this panel myself because it's a subject I've often thought I should know something about. And here are four smart people. And this brings me to the first item on our moderator script, which was, please silence your cell phones if you would. We are recording. And panelists are told that you must turn your cell phone off. So if you would just, oh, look, cats. It's so cute. I'm sorry. Never mind. Those of you who are doing this for CLE credit, you need to get the forms outside. You need to get your certificate of attendance and your evaluation form and turn in the certificate of attendance after the event, or you will not get CLE credit. I think that's all the obligatory things that we're going to do. The general theme of free expression on the web is, I think, so huge and so pervasive now in the way we live that it's almost impossible to put boundaries around it. We live, this week, we have seen two very consequential events, and they're just one of a stream. One of them, of course, is the overwhelming vote in the House last night to try to put some hard limitations on monitoring and eavesdropping by the NSA. The other is the grant of cert on Monday by the United States Supreme Court in the case of Alonis versus United States and the issue of, whether putting statements about chopping up your ex-wife on Facebook is a true threat or just sort of, self-expression. Of course, more recently, less recently, but not long ago, we've got the case in the European Court of Justice, the Coseca case, which is about the emerging claim for a right to be forgotten. This is an order issued by the court to Google telling it that it cannot put on the web certain public, truthful, legal information about an individual's foreclosure development because this violates his right to be forgotten. And since that decision, it's my understanding, Google has received roughly 12,000 requests from people in Spain.
That was just the first day.
That was the first day, okay. And Google subsequently crashed, so I have not been able to get cats on my phone since then. And a number of panelists are eager to talk about that. You may have questions about it too. Questioners may be interested in all these issues, and we have discussed structuring this panel as best we can to leave as much time for questions and discussion from the audience as we can, because the subject is so big. With that in mind, each of our panelists is going to talk for about 7 minutes. At the end of that, I may ask a question of the panel, or we may just go straight to questions. Now, on the matter of questions, please remember that we are recording and videoing this event. So if you have a question, please raise your hand or stand at your seat, and we will bring you the microphone, because that way the people will be able to hear what you're asking when we put this on the web or whatever. So let me introduce this terrific panel, which I'm really looking forward to learning from. On my immediate right is Danielle Citron, who is professor at the Francis King Carey School of Law of the University of Maryland, and who I think is going to tell us something about cyberbullying, and so this relates to Alonis, obviously, and some of the legislative responses that have been proposed to the issue of cyberbullying and so forth. On my left is Emma Alonso, director of the Free Expression Project at the Center for Democracy and Technology, who, and again, this wires in to all of these themes, is going to talk about private intermediaries and their importance in the system of free expression on the web, which, of course, none of us can engage in free speech, just directly from our computers. We have to go through somebody. And her principle, which is that Section 230 of the Telecommunications Act of 1996 is as important as the First Amendment, is important on the web as the First Amendment is for those of us who live in meat space. Third, on my left, far left, is Tim Sparapani, Vice President of Government Relations for the App Developers Alliance. And he's got some news and thoughts about the battle going on in the states over, what we would call slap suits against consumers who put negative ratings or hostile comments on consumer rating sites, and who may be then threatened with ruinous litigation if they don't take down their criticism of a given business, and to what extent existing law fits into that. And then finally, we have on my far right, Gabriel Rotman, who is Legislative Counsel and Policy Advisor to the ACLU's Washington Legislative Office, who will kind of sum it up by talking a little bit about internet governance and net neutrality. And I am, in this area, by far the most ignorant person on this table. My only job, which I intend to do savagely, is to enforce the time limits. So I have my timesheets here, and I will be passing, at the 7-minute mark, I'll be passing my Porky Pig notice, which you really don't want to get. So with that, let's get started, and I'll turn it over to you, Daniel.
Yeah, I was hoping to do sort of less than 7 minutes, but who knows, whenever I get to talking, good knows what happens. Okay, so I'm going to talk about sort of a small part of the sort of broader online harassment phenomenon, and that's revenge porn. So when we say the term revenge porn, it's sort of a catchy phrase, but what we're talking about is the non-consensual disclosure of nude photographs of individuals, often shared in confidence with an expectation of privacy, and then disclosed in breach of that trust. Revenge porn is increasingly prevalent. The Cyber Civil Rights Initiative did a survey, and within like a month's time putting up a survey about the phenomenon of revenge porn, the group got over 1,800 responses. It's like understudied, like much of online harassment. But oh, sure, it's a significant phenomenon. Yeah. No, thanks for nudging me. That is one in which we're increasingly hearing about. I'm heartened by some of the legislative responses to it. We've seen, so what's so wrong about, non-consensual pornography? It has led to, it's terrifying for victims. It's led to offline stalking and physical attack in real-world cases of rape. It really, it has a powerful impact on people's economic lives, right? So individuals have lost their jobs, and when seeking new jobs, it can be difficult to find one, because we know that like 90% of all employers use Google as a sort of a CV search. And in 70% of cases, they say there's a negative result. And in breaking that down, a large category of why employers don't hire people is because of ill-advised photographs. So it's not that employers might think, oh, these individuals put them up themselves, but simply that it's just not worth the time and effort to hire someone who others, clients, might think less of them for hiring them. And it has a profound emotional impact on people's lives. So we think, all right, why can't civil law or current existing criminal laws address it? Cyberstalking laws typically only apply if you have unwanted communications made directly to individuals. The federal cyberstalking statute is far broader and more helpfully applies to communications that could be posted online but not directly sent. But we know that law enforcement doesn't take cyberstalking seriously, let alone revenge porn. And so sort of federal prosecutions just simply don't happen. There have been 10 in the past 3 years, federal cyberstalking prosecutions. 3 have involved revenge porn, but can you imagine 10 of, searching Pacer? That's not a whole lot of cases, right? What about sort of state criminal laws? There aren't laws. There are laws for the non-consensual taping of individuals and then subsequent disclosure, but not where there has been consensual sharing of nude photos and then non-consensual disclosure. Civil suits are always theoretically an option, right? We can sue for public disclosure of private fact, intentional infliction of emotional distress, but we know that tort suits are incredibly expensive. And so the victims I've been advising in the course of writing my book, Hate Crimes in Cyberspace, they just can't afford their rent, let alone a lawyer. the group Cyber Civil Rights Initiatives making a great attempt. So for everyone in the room who's a practicing lawyer, there's such an incredible need for pro bono representation of cyberstalking victims and revenge porn victims specifically. So if you're interested, please come talk to me and I can connect you with the Cyber Civil Rights Initiative. But it's often just not an option. It's too expensive to sue, let alone pay for a computer forensic scientist to figure out the actual identity of the posters. And even if victims have funds to sue, it's often who they're suing doesn't have a deep pocket. That is, they're essentially, judgment proof. So it's not worth expending the resources. We know because of Section 230, which Emma's going to talk about, we can't sue intermediaries for the content posted by others. So that leaves all these costs of revenge porn externalized, borne on victims who can have very little to protect themselves with. And so I've been working with lawmakers around the country on efforts to criminalize revenge porn. There have been in the last year, there's been 10 states that have criminalized revenge porn. New Jersey had a statute that have a criminal sexual invasion of privacy that, if we remember the Tyler Clementi case and Darun Ravi, he was convicted under the New Jersey criminal invasion of privacy statute. Oh no, am I running up against 5 minutes?
5 minutes.
Oh my golly, really? Okay, so I always think I'm gonna be so short. I guess it doesn't happen that way. The key thing that we've been working on as advocates working with lawmakers is to ensure that these laws are narrowly drawn. They're not vague and overbroad. They ought to have a mens rea requirement of posting or disclosing nude photos, knowing that they were shared in confidence with an expectation of privacy and that they're posted in violation of that trust. There should be a harm requirement, an exception, like a safe harbor, that if a photo like Anthony Weiner's appears, that matters of public interest shouldn't be covered by these statutes. You gotta throw an Anthony Weiner in there, no, if you're gonna talk about revenge porn. Do lawmakers always listen? Not necessarily, so maybe in the Q&A we can talk about what's sort of not terrific about some of these bills. And I'll stop.
Thank you. All right, Emma.
Great. Well, thank you so much for having me on the panel, and I'm looking forward to our discussion. And just to take a step back and give a little bit of context for the kinds of things that we as lawyers working in the area of free expression online have to think about when we're thinking about whether it's steps to address issues like revenge porn or cyberstalking or cyberbullying or any of the other myriad kinds of online content issues that people want to address through law or regulation or some kind of policy response. There are the First Amendment concerns, of course, that Danielle was just sort of outlining and looking at maybe a model revenge porn statute. But we also need to think about the impact that any of these laws have on sort of the whole ecosystem for online speech. So if you think about the First Amendment, that protects us as speakers from the government passing laws that would abridge the freedom of speech. And that means that we, all of the speakers kind of at the edges of the network have this strong First Amendment protection to be able to, which hopefully ensures that there's a diversity of viewpoints and opinions and ideas and information out there that ideally we can all share and exchange with each other. But because of the technical nature of the internet, we all depend on some kinds of intermediaries to get our messages to each other. The internet is a distributed, decentralized network of networks, and it means that if I want to, say, tweet about this panel that I'm on, I put my 140 characters into my account at Twitter, and I hit tweet, it goes up to Twitter's servers, and then it's from Twitter's servers that information is shared with anybody who wants to read my tweet. Even if I'm hosting my own website from inside my own home and I'm running my own server, I'm still depending on the transmission facilities and routers and probably other online services like search engines in order to get my message to other people. So all of these different intermediaries really play a big role in actually bringing to fruition this promise that the internet has for being a platform for free expression. And so one of the critical questions about free speech online, particularly in the early days of the commercial internet, was what's the nature and the legal status of these intermediaries? Are they like newspapers? Are they like telephone companies? Are they like broadcast TV? And one of the big questions in particular has been, are online services that allow other users to post content properly considered publishers of that content? And there was a case back in 1995, Stratton Oakmont versus Prodigy, which is a lower court case in the state court system of New York, that was surprisingly influential for being a case from the Supreme Court of New York, that basically found that the online service Prodigy, which did, among other things, maintained a message board, I think called Money Talk, where people could exchange ideas and views about all kinds of financial matters. On this message board, one of their users posted a comment that was allegedly defamatory of the financial institution Stratton Oakmont. Stratton Oakmont wasn't happy about this and sued not only the anonymous commenter, but also Prodigy as the maintainer of the message board. And the New York court found that looking at the kinds of things that Prodigy did, the fact that they provided content guidelines about what sorts of things you could post on the message board, the fact that they moderated comments and would kick people out for being off topic, and the fact that they had filtering software to try to screen out offensive language, meant that they were basically exerting editorial control over content, and so, of course, should be liable as publishers of potentially defamatory statements. But this was a big, big concern for people who were really interested in the development of the, at that point, nascent commercial internet as something that could be widely used by a lot of people. The implications from this decision were, one, that it would massively disincentivize online service operators from doing any kind of moderation or filtering or even specifying content guidelines. It was very unclear how much activity an online service provider would take that would suddenly put them in this kind of publisher standpoint. Would having specialized message boards saying, well, this is our message board for political discussion, this is for financial, and this is for talking about kittens, would that be enough to make you considered a publisher and therefore potentially liable for any of this content? And then just generally, the idea that a content host could get taken to court, and even if they could ultimately disclaim liability, the fact that they would have to go through a whole court process would very likely make them much less willing to host user content at all. Or if they did host user content, make them much more likely to try to actively pre-screen it, and likely overscreen to ensure that they were not hosting anything that could ever possibly conceivably be the source of a lawsuit. And if that concern seems a little out there, just think of the, I think something that Danielle mentioned, that a lot of times if you're trying to sue somebody over what they've said about you online, the speaker is not going to have nearly as many resources as the platform, maybe much harder to identify. Platforms are an easy target to bring into a lawsuit, so the chances that there would be lots of litigation over this were really high. So in response, Congress passed what became Section 230 of the Communications Act. It was part of the Communications Decency Act, most of which got struck down in the Reno versus ACLU case. But 230 stayed and basically has two key provisions that reflect these concerns that came out of the Prodigy case, that operators of content platforms and other interactive computer services, basically all of the intermediary search engines, ISPs, everybody, shall not be treated as a publisher or speaker of content provided by someone else, just blanket immunity. And they also won't face liability if they take steps to restrict access to objectionable content, including lewd or lascivious or violent content. And that's, I think, been read fairly broadly to just sort of support platform operators' ability to have content guidelines and really kind of set the boundaries of how discussion goes on different platforms. These are really strong protections. They've been tested many times in a number of courts, and there are some cases that sort of define the outer edges of the boundaries. But basically, it's such strong protection that it provides a lot of certainty for online service providers, keeps them willing to host users' content, which is good for free expression, and I'll stop.
Tim?
anything to avoid the Porky Pig. It really is. You should show everybody. This is fabulous, by the way.
Porky Pig.
Probably a copyright violation, but that's
It's
okay.
definitely one because it says down here Santorum campaign. So somebody else's copyright violation stolen by me.
Oh, points for snark.
Yes.
So happy Friday afternoon, everybody. Thank you for the invitation to speak. I'm going to try to make 4 related points. I don't claim to have any answers here, but I've got some questions that I think we all need to confront and think about what's coming and what's next. And based on what we've just heard, it's going to be important. I think we got the title of the panel wrong because we're talking about the web, and a lot of the questions about the web have been sort of worked out, I think, with respect to free expression. What hasn't been worked out is what the heck does it mean that we all carry multiple of these around with us, or that we're all wearing wearable technologies, Fitbits, we're going to have iris scans, Google Glass, what have you, and a thousand other fabulous things. And I'm excited about all of them. And frankly, that the Internet of Things is coming, that idea that everything around us is going to be gathering and capturing information. And I think what that leads to is 4 related points, which I'll try to spit out and walk through really quickly. One, we are all now, or soon will be, publishers. And we have a right to publish, and it means a lot, and it produces a lot of tensions with typical privacy rights in particular, but also a series of speech limitations around the world and here in the United States. 2, when we're all publishing and we're carrying things around with us in real time, we have the tendency to speak in real time and react in real time because we're publishing in real time. And that means that people get ticked off in real time, and they say things they might otherwise sometimes regret. They take pictures of people in unflattering lights, or at least they're perceived to be unflattering lights. They say things, they react, they comment, they do trollish things, and that leads companies which are respecting, trying to protect their own reputations out there to take egregious responsive actions, which have led to a series of these attacks on people for saying, man, your customer service just stunk, and therefore I'm going to sue you as an individual for defaming my company. I think we have to think about what it means that that's happening when we're all publishers. Point number 3, we have this right to be forgotten, which has been enunciated by first the French and then now the European Court of Justice. And that's going to be really challenging if we're actually embodying, in the European perspective, a human right, which is how they think about it, to literally be exempted from publishing by others. Especially when the engineering reality is that delete, I'm going to blow people's minds here, delete doesn't actually mean delete. Yeah, that's real. So here's the dirty little secret about the computer world. Even when you hit delete, that's not what happens. It may be deleted. The file, the image may actually get overridden. It may not be overridden for months. It may lie out there. It may never get overridden. It may just be harder to get. But it oftentimes doesn't mean delete. So the idea of there being a right to be forgotten clashes with the fact of engineering, and then we have a real problem. And then 4, when we're thinking about what kind of speech we want, to bring us back to Danielle's world, and a very important set of questions, of which revenge porn is just one of the problems out there, is if we attempt to control speech, no matter how we're producing it and publishing it in the real world, through these devices, through our wearable technologies, through the wall monitors, which are our thermostats, or our refrigerators, which take pictures of us and tell us what we like and what we don't eat and when we eat. And then we try to filter out the bad stuff. Turns out the very filters that filter out the bad speech are the same exact filters that are used by really nasty governments around the world to suppress speech. They're the same filters that grab and take our thoughts and record them for surveillance organizations for governments around the world. And so we run into a real problem in that if we want to take out some of the speech, we end up facilitating exactly the kind of structure of the internet and of the broadcast publishing medium that I think we all find useful and worthy of protection. So I think those are sort of like, that's the set of problems that I see coming, and frankly, the dawning of wearable technologies, the dawning of the Internet of Things means we're going to have far more publishing. You're going to have far more imagery taken of you. You're going to have far more things said about you and about other companies. And we got to get it right, or all of the great stuff that will happen through the Internet of Things, through wearable technologies, through ever faster, smarter devices, will be challenged.
Thanks very much. I hope Porky is fair use. I really, really do. So I'm going to be a little bit of a rebel and depart from my prepared remarks, because I just want to follow on kind of what Tim was saying. And he raised very serious concerns about the tension between privacy and free expression online in terms of in the commercial context. And one of the topics I was going to cover was what's happening with internet governance these days. The internet, it's not governed like a country, like a nation state. It's governed by a multi-stakeholder group of private entities that, in a very practical and concrete way, determine how various pieces of the internet work. And the main thing that I'm going to talk about is Edward Snowden and the NSA revelations, but that's intimately tied with this concept of this issue of what's happening with internet governance today. Following the Snowden disclosures slightly more than a year ago, there have been increasing calls among countries including Brazil, Russia, China, for the US to divest itself of the remaining ties that it has with the various entities that make up the internet government. And they've done so because the US, as a mistake of history perhaps, is where the internet was created, and it's also where the entities that govern the internet, that's where they've ended up being geographically. But the calls are what they're essentially asking for is greater nation-state control over the organs of internet governance. So there's been a call for what's called data localization, which essentially means offshoring the servers, which might be okay if you're talking about a place like Germany, but if it's a place like Russia or China, it's an invitation for greater government snooping. But also, and perhaps more troublingly, what's been called for is moving the actual addressing system behind the internet to under greater nation-state control. So anytime you enter www.google, instead of a private entity determining that Google means a certain string of numbers, it's actually a government, which makes it much easier to suppress speech. But in any event, that's the internet governance aspect of the whole Snowden thing. But let me actually talk about what's happening with the NSA surveillance issue specifically. And this is where the privacy issues when it comes to commercial privacy versus free expression are hard. The privacy versus free expression issues when it comes to the government engaging in mass surveillance of internet communications are easy. And it's not a new problem. It's a new problem because technology has advanced to a place where snooping is easier, where mass surveillance, where collection, analysis, where actually digging into the information and making it usable, that's easier. But this is an old problem. In the last century, there was a program called Operation Shamrock, where the government, actually the NSA, would go into each individual Western Union telegraph office, quite literally take stacks of paper, take them to an office, copy them, bring them back at the end of the day. And they would collect them en masse, and this all came out in the 1970s. What's happening now, and what's been disclosed by Edward Snowden, is actually not that different. So I'll try not to I'll try not to walk into the 5-minute and especially not the 7-minute. But
You're doing great.
But I'll tell you. So essentially, what Edward Snowden revealed was two big buckets of collection. One, which I think most folks are familiar with, is bulk collection of telephonic metadata. So the data about data without any discriminator. So the first document that Edward Snowden, the first document that the Guardian newspaper revealed was a secondary order that was issued that required Verizon Business Services to hand over all call records within a certain amount of time to the National Security Agency in bulk without, again, any discriminator. And it was subsequently revealed that, in fact, similar orders had been issued for other telecommunications companies. It's currently unclear exactly how much information is being funneled directly to the NSA without a discriminator, but it's quite possible that it's a large proportion. It's important to note that that information, again, is metadata. It's not content, which is one of the defenses that the administration and the intelligence community have raised. But what's really interesting, and this again gets to this brave new world that we're in, where just the aggregate amount of data in our digital world creates new and exciting opportunities, but also new and frightening dangers. And that is that the metadata itself, because there's so much of it, and especially the longer it's collected, the more it reveals about our most intimate, the most intimate aspects of our lives. That metadata is domestic. There's a second large bucket of surveillance which has received less attention, but is perhaps even more troubling. And that is under Section 702 of the FISA Amendments Act of 2008. Which was the first time that Congress passed a law governing the foreign intelligence collection of international communications. Right now, as long as you reasonably believe the target of your surveillance is a non-U.S. person overseas, you can collect that information for foreign intelligence purposes broadly defined. There are very few fetters on that collection, and what that's created is what's now known as the Section 702 backdoor problem, which means that once you've collected the information, you can query it using U.S. person identifiers, again without any check. So it allows for the collection of content, emails, telephone calls, text messages, without any of the traditional checks that the Fourth Amendment, the Electronic Communications Privacy Act, or even the Foreign Intelligence Surveillance Act, which is supposed to cover this type of surveillance, without any of the checks they put in place. 5 minutes. So I'll get into what's happened recently. I mean, I would note that there's significant movement in Congress, including a vote last night on an amendment to the National Defense Authorization Act that would deal with that Section 702 backdoor problem. It would disallow queries for U.S. persons without a court order. But before I get to, but hopefully I can get to all of that stuff in the Q&A. The fundamental question is, why does this matter? I deal with a lot of anonymous speech issues. I traditionally the First Amendment person in our Washington legislative office. And we tend to think of anonymous speech in the context of the government forcing the disclosure of membership lists of groups like the NAACP. But when it comes to bulk surveillance for national security purposes, that's happening with everyone all the time without limit. Bulk surveillance is a problem because it discloses very detailed information about our social lives, our political lives, our romantic lives, and the way in which the law has been interpreted that we now know because of Edward Snowden is fundamentally antithetical to American notions of the right to be left alone. So I'll just end with that. But again, the commercial privacy issues that we're talking about right now are legitimately hard. The government privacy issues, the tension between national security and civil liberties, and I don't believe there is one, that's an easy answer.
Well, that's great. Now, I think we can go straight to audience questions, but I do think I need to say for the record, and you might want to turn the camera off just in case, but my Porky Pig does have Santorum campaign, and this brings it within the realm of parody, squarely within the line of the Acuff Rose music case, and so I've committed no infringement. That's my story, and I'm sticking to it. So let's see if we got any questions from the audience. In the back there, wait for the mic.
Thank you. So my question is for Mr. Scarpani.
Yes.
You mentioned wearable technology that takes our healthcare information, takes it in every day.
Right.
As far as I understand, the only thing protecting that information is a contract I may have with that company, a terms of use and privacy contract.
Yep.
Do you think that's strong enough protection, or do you think there should be a change in the laws for healthcare apps and healthcare wearable technology, with the possibility that, if my healthcare app goes bankrupt, it could be acquired by another company that would take my healthcare information and I wouldn't have a contract with them?
So
good questions. Let me try to unpack them. I think of these as sort of privacy issues, which is sort of my core knowledge set. Here's the good news, is that despite the fact that we don't really have a broad-based commercial privacy law in the United States the way they do in Europe that governs how companies use data, any statement that a company makes, a promise, think of it as through the privacy policy, a terms of service, a statement on the website, however it interacts with you, about what they're going to do with the data or not do with the data is actionable. It's in an enforceable promise. Either the state attorneys general or the Federal Trade Commission can take action if there's a breach of that promise. Now, it doesn't mean that there won't be breaches. It doesn't mean that companies won't do silly, nefarious things or sell it out the back door, and that's the real problem in my mind is what are we going to do about data brokers who are buying data from first-party companies and selling them to third-party companies, and then the third-party companies are selling them subsequently. So I think we're okay there, and I think our laws are going to end up in the right spot. I think generally the incentives are okay. With respect to bankruptcy, there's a case called Toy Smart, or maybe it's Toy Smart. I never know from the caption because it's jammed together, which talks about what happens to lists in bankruptcy, and that's sort of the seminal case. And before that case, we were in a lot of trouble as consumers. Company goes bankrupt. This happened in the dot-com bust, 98 to 2000. All these companies got built up, the dot-com companies, and then a bunch of them went bankrupt all at once. And the only asset that was left was the lists of consumers, right, and some of their data. And some of the companies said, aha, we can sell this. And then until this case, they could, and after that, they really can't. So I think we're okay with bankruptcy. I think the bigger problem that's left is not about those issues, but about when our wearable technologies or the devices that we're carrying around with us don't gather data about us, they gather data about us and people around us. And that's the area that I think is important for this conversation in particular, because I don't think we've thought about what it means that I have a device that can be capturing sort of passively information about others. I can consent to that interaction with my Fitbit device, that my glucose monitor, my phone, which monitors my heart rhythms or takes pictures or hears my voice and records my voice. It's much harder, I think, to get that consent worked out with respect to people around me. And then when that thing begins to publish at my behest, because I want to broadcast what my experience is to the world, a right I think we should have, we haven't quite figured out the tension there for other people's being depicted and having their imagery or their voices or their heart rates captured by a device. And that's, I think, the tension that we don't have questions yet figured out. That's my feeling about it.
Anyone else on the panel want to weigh in on that one? The gentleman with the mic here.
Yeah,
And then
Peter Swire from Georgia Tech. I wanted to ask the panel about civil liberties, which is a hooray word in this group probably, and libertarianism, which might not be as much, at least for the economic and social side. So 3 areas. One is cyber stalking and revenge porn, where the libertarian tendency would be not to have laws that get in the way. The next is privacy. So the United States has a series of right to be forgotten laws, like the Fair Credit Reporting Act says, last 7 years, no more than that, or a sealed juvenile record. So, and the Sorrell case and other Supreme Court and lower court cases have sort of questioned whether we can put limits on data speech like that. And so a libertarian tendency might say that we can't have these privacy laws. And the third is campaign finance, right? Money is speech, we can't limit it. And so how do you all work through your civil liberty tendencies and your libertarian tendencies as you're thinking about the different goals we have out of the internet?
who wants to go first?
I think I can go. Peter, I think I sort of, at least in this project about ways in which we're protecting against evasions of sexual privacy, I sort of feel like I am a civil libertarian, even though I'm sure everyone's now saying, what is she talking about, right? Because privacy protections, or I guess the protection of communicative privacy, right, that fosters expression. So with an expectation of privacy, whether it's with the backing of criminal law or civil law, we're going to feel freer to share in the bedroom or share communications of pictures with one another. But without that expectation of privacy, we're just going to see less expression. So in some respects, I realize I'm talking about bringing law to bear in a narrow sort of set of actors, that is the posters themselves, not intermediaries, right? But But to me, it's a project about civil, the reinforcement of free expression rather than its squelching. And I don't think we often see that when we talk about cyberstalking. We always think about the poster's free expression or the cyber mob's free expression, but we forget about the individual who's silenced.
Well, and building on that, I mean, I think a lot of times in these discussions about privacy and free expression, it's, they're always presented as oppositional forces. But, as Gabe was mentioning, a lot of First Amendment work is around the right to anonymous speech and the right to pseudonymous speech. And I think there is, I think there are some cases certainly where the interests are really in tension, but there's a lot to supporting, as Danielle's saying, somebody's ability to express themselves freely that kind of depends on having privacy protections. So I think in the balancing civil liberties, part of it is civil liberties with less regulatory or libertarian tendencies. Part of it is making sure we're thinking about all civil liberties, not just picking our favorites. But also it's again kind of echoing Danielle's point, the narrowing. And so looking at something like right to be forgotten, in looking at juvenile arrest records or FICRA. So like FICRA has, I'm going to get the numbers wrong, but something about like you can't report or you can't include reports about someone's bankruptcy in their credit report after 10 years, and a couple other kinds of, it just basically covers the suite of financial issues you might have had and puts a time limit on when they can be included in your credit report. So that's, you contrast that to the case in Europe that was the center of the right to be forgotten. This was also a case about a man's financial issues and foreclosure on his home. But as opposed to FICRA, where we're talking about a specific instance, a credit report that will then be used by lenders and by mortgage providers and credit issuers to make specific financial decisions about a person. The European case is looking generally at what effect does this information about the foreclosure on the man's home have on his general reputation in the community. And so I think those are actually two pretty different circumstances. If you're looking at something like FICRA that's narrowly tailored about the particular uses of a certain kind of data for certain purposes, I think that it makes a lot of sense. You can really see the point, the goal that a law like FICRA is trying to achieve. So something like that, I think, does a lot better job at striking the balance between privacy and free expression than something like the case in Europe, which was about no longer linking to information that was true, a matter of public record, and also lawfully hosted on the internet. That was just like so far on the side of putting restrictions around access to information that one would expect, of course, to be accessible, that I think they're really pretty different cases.
Go ahead.
Thanks. So I think on all three of the topics that you raised, the ACLU is often accused of being sort of a First Amendment purist or a First Amendment absolutist, and that's largely because the ACLU has a history of defending unpopular speech or controversial speech. But the history of the First Amendment is not an absolutist enterprise. It's a search for limiting principles. When the First Amendment started to actually be a thing, which is not, it doesn't go back 230 years. It only goes back about 90, maybe 100. There were no limiting principles. It was completely up to the discretion of the jurist. And so the search has been for limiting principles. The problem with a lot of these things right now is that if you get out of, there are two ways in which you can get over the First Amendment if you want to restrict speech, right? One is if it's a historical category of speech that has not been protected, obscenity, speech that's integral to criminal conduct, for instance, price fixing. That's easy, right? Much less scrutiny, government can do it very easily. But when it comes to other areas where there hasn't been historical understanding that speech is unprotected by the First Amendment, it receives much stronger scrutiny and likely should. And in the three areas where the government has allowed a content-based speech restriction using heightened or strict scrutiny, One is the Austin v. Michigan Chamber of Commerce case, which is connected with campaign finance and was at issue in Citizens United. And then the other two, one is Burson v. Freeman, which is getting rid where you can restrict electioneering speech, but not other speech within the radius around a polling place. But the third, I think, is a cautionary tale when we're trying to balance all of these equities, right? And that is the Holder v. Humanitarian Law Project, which upheld the application of the material support statute to purely peaceful, purely lawful speech with designated terrorist organizations, trying to educate them about how to become more politically involved or aware. And that decision has been extremely controversial, and frankly I think is one of the more dangerous decisions in the past 10 years. So in the search for limiting principles, it's not a question of being an absolutist, it's a question of actually finding the appropriate limiting principle.
Garrett, can I jump in?
Absolutely.
So first of all, it's always fun to get a question from Peter Swire, who is the Clinton administration privacy czar, and then try to respond. So thanks, Peter. Appreciate that a lot. I don't have. Let me speak here as Tim rather than as Tim representing the App Developers Alliance. I have a notion about where the world can go to bring some harmony to some of this, and it's more in the commercial and consumer side rather than through the cyberstalking, revenge porn, or campaign finance stuff. I wish I was smart enough to kind of harmonize all that, but I have a sense that we can both empower individuals to have more control and to deny others unlawful control about them if we begin to think about a bundle of these opportunities and rights as sort of a first-party, third-party distinction. And the world that I would put in place, the set of rules, if I were in charge and I were the king and I could write the rules, would look something like this. We give individuals the opportunity as a first party to give permissions to others to do things on their behalf with their data or with their speech that the individual wants to have happen. So we put the individual, we say, you're smart enough to figure this out. We believe you're going to make choices that are wise. Here are your opportunities to do so. You, individual, are now empowered to share your information or your data as you see fit to get things in the world that are going to benefit you. And the opposite of that is, of course, you get to deny the ability for people who have passively collected without your notice, your control, the ability to do things that would be against you. Sometimes, of course, there will be moments when first-party individuals want to have a company they're interacting with do something with another company that is to their benefit. So we have this sort of first-party, third-party. Again, where does the permission go? But I think you can figure that out. I think what gets really, really tough is what happens when third parties act against our interests with data about us. And I'm thinking about things that would be used not dissimilarly from what Professor Citron is sort of talking about. You see these moments when we know pictures or data or information is going to be used to deny us a job, to prevent us from getting into the right school, to prevent our kids from having opportunities. And that's where I think this first-party, third-party world can actually really do us a lot of good if we begin to build our laws around empowering individuals to both say yes and no, and then identifying the moments where there really will be discrimination. There's going to be price discrimination. There's going to be redlining. There's going to be people who are going to block people from getting into schools or having educational opportunities. There's going to be people who are going to cost people jobs or the ability to get health care or the right-priced health care. And I think as a society, we just are going to have to say no at those moments. And we might have to have a series of thou shalt nots to those third-party companies. That's the world I would put in place. I don't know if it'll work, but it's the best idea I got.
And I want to say something quickly, and then we've got that lady in the red sweater as our next questioner. As a First Amendment jock, and I know you're aware of this, but it's important to point out that there is a tendency now in First Amendment discourse to blur the distinction between a credit report issued by a credit agency and, the New York Times. And a credit report is a commercial product that is prepared for commercial purposes, and it is a perfectly valid, under the First Amendment, function of government to say, no, you can't put a picture of Epps in a bathing suit on his credit report. You can't put his blood type, you know, you can't put photographs taken through his windows. A credit report has to consist of the following information and nothing else. And that's not the same thing as saying that if someone knows that I was sued for a debt 15 years ago, they can include it in news reports or other sites about me. But the tendency, increasing tendency, and we've got the expert on this here in the audience, Tamara Piety, the tendency is for business to now take the First Amendment and say, no business regulation can be done because it'll violate the First Amendment. We have a case where the cigarette companies have been told by the courts, yes, you can block cigarette warning labels because that's compelled speech. That's your freedom of speech to say, you know, what you want about your cigarettes. We had a case, there's a case that's just been filed in district court in Washington against the higher minimum wage because the plaintiffs say that having to pay higher wages to their workers will restrict the amount of money they can use for advertising, and that is an impact on their First Amendment rights. So we have to be very careful when we're talking about restrictions on use of information and content-based restrictions on speech. They're really quite different. Ma'am, in the back. Okay, the gentleman in the white shirt, all the way back.
Going back to Tim's last comments, you seem to be saying that there's probably a meeting of the minds between the first party and the second party. But I'd like to ask for a show of hands, how many people actually read user agreements and privacy statements on their devices and software?
Privacy geeks, like we're allowed though.
Okay, how many want to say that they don't read it? Okay, now, if that's the case, is there a meeting the minds? Are especially the younger generation, I'm in the older generation, giving away their privacy rights by taking these contracts of adherence and not knowing what they're giving up in the way of privacy? And is that something that somebody ought to be looking at more closely?
So I'm going to jump in because you sort of addressed that to me, but I hope others will comment. I couldn't agree more. I led what I consider to be a very successful effort to create what is the first consumer advocacy organization, privacy advocacy organization, publisher, technology industry agreement in privacy in the last 20 years. Last summer, we were able to conclude before the Department of Commerce a voluntary set of agreements to create a new type of privacy disclosures that will be on apps. And what we'll be doing is that in 2 screens, and no more, you will have answered for you with every app that you open in the future 2 questions. What data does this app collect about me, and what types of third parties will that data be shared with? And it's not a complete resolution of your problem of what do we do when we have these 10,000-word privacy policies that, of course, none of us read. But it is the beginning, I think, of a means of getting closer to the meeting of the minds that I think is necessary to create this world. I have this notion, and we're kind of far afield here, but I have this notion that privacy is getting to be more about property rights, and that might actually be a bit of the way that we can solve some of the problems that I think you've identified. I don't want to
jump in.
Well, I would just say the other, kind of the other side to that, you know, I agree with Tim that finding good ways to disclose to people what's actually, you know, clear and comprehensible ways to disclose to people what's actually going to be happening to their data is incredibly important. But there is also, you know, something to be said for just getting a baseline consumer privacy law in the country. And as, you know, something that's like, I think there's a proposal from the Obama administration that came out a few years ago that's based around fair information practice principles that sets out, you know, a kind of a baseline understanding that so that people generally have a basic expectation of what can and can't happen with their data, and not to have it be set at the most restrictive use of data for everybody all the time always, but to have some kind of fundamental level of protection that everyone knows, you know, restrictions on collection or use or how people use data, minimization requirements, so that people get rid of data they're no longer using that they've may have collected about you some kind of, comprehensive set that sets a foundation that then we can build lots of interesting kinds of services and uses of data on, but giving people that kind of fundamental level of assurance of what's in those contracts that they're not spending their full-time reading.
All that's very nice, but why does every European site have an option in or an option out on cookies? And none of our sites
Let's
have
do
it?
one question per, and we'll move on to this gentleman here.
My name
is Marvin Cherry from Chicago. I was wondering about the application of the common law to some of the problems we're talking about with the internet. And I'll give you an example. If someone were standing out in front of a hotel with a sign saying unfair or false things about you, we know what to do with that person in terms of common law litigation. Have those principles evolved so that aside from the legislative things that we're talking about primarily, have they evolved with the internet so that the common law principles are being pulled along to evaluate this conduct?
I hope everyone understands the question, and it's about how are common law principles that have to do with defamation and so forth being transformed as we move out of the world of things and into the world of the internet. Who would like to take that on?
I could take it as a first go. I mean, when it comes to individual speakers, the rules certainly apply. That is, laws of defamation. You can sue a poster if you can figure out who they are. And I mean, what has been argued in some cases is that, like, well, we're clearly joking around. It's an opinion. It's a parody. And sometimes that has more legs, that argument, when it comes to sort of message boards that are clearly kind of these destructive message boards. And, of course, I've kind of bought into, okay, it's a zone in which this is clearly a parody or opinion, when if said somewhere else, it's clearly a factual falsehood about someone. So that's the sort of one main difference I've seen. But otherwise, the law of defamation is the law of defamation. It's elastic and works, online. What Emma, I'll have you take over now, because Section 230 does transform the way in which publishers and distributors are addressed.
Right. So we have the statutory framework with Section 230 that basically kind of overrides traditional notions of publisher liability for any of the intermediaries kind of involved in the transmission or posting of content. If I make a defamatory comment on Facebook about Tim, I can.
What did I do to you, man?
And you want to find out what you did, so you try to sue me. As Danielle's saying, the common standards of defamation would apply, but 230 kind of make sure it stops there, and that you don't also start bringing in my ISP or Facebook or any of the other intermediaries in place. Now, if I'm posting somewhere else and under a pseudonym, there's also, the courts have worked out standards for when can Tim kind of pierce the veil of anonymity that I've set up around myself to get information from to get information from my ISP or from the platform that I've posted on, so that he can bring a suit against me. So there has been, development around those sorts of standards.
I guess one other element, I don't know, has anybody mentioned slap suits yet?
No, go for it.
I mean, the internet as a communications platform has led to, because it's led to a proliferation in communications, has led to a proliferation of problematic communications, or communications that folks would find problematic. And so it's also led to a growth in what are referred to as slap suits, strategic lawsuits against public participation. It happens a lot in the paradigmatic case is you have a developer who's trying to build a development, and then you have a local blogger who's opposing that development, and then the developer, even though the case is frivolous, will bring suit alleging defamation or some other harm. And what is the response to that, actually, in the States has been a number of anti-slap suits, where offenses like defamation, torts like defamation, actually have to be pled with greater particularity than other claims. And the way in which they usually work is you bring the claim, and then there's you get an initial bite at the apple in order to have it dismissed. There was a federal anti-SLAPP suit that was proposed, I think, 2 years ago. It was controversial because there was a concern it would interfere on a federal level with civil rights suits, some national security suits, essentially litigation where you need to get to discovery in order to build your case. But they've proven relatively effective in the states. California has one of the strongest. There's some abuse, but among free expression, especially free expression online advocates, they're very popular.
I think we certainly have time for one more, and this lady who has been very patient is that one.
Thank you. My name is Sarah Shelf. I'm at Emory Law School. I was at a privacy CLE, I think earlier this week, where somebody made this statement that what we are dealing with is technology, or what we're dealing with is rules and regulations that apply to technology that's 20 or 30 years old. And they were talking specifically about big data and privacy, and they were talking about FTC regulations, where FTC has stopped regulating, because what happens is by the time you get through the notice and comment process, or you formulate the regulation, then get through the notice and comment process, the technology has passed you by. So your regulation no longer applies to what the current technology is. And so in the absence of any regulatory authority that they can execute quickly enough, they're just looking at, they're saying, look at our past settlements, and you'll figure out what it is you can and can't do. And I think that's right. I think technology, the pace of technology is moving so quickly, and we're still arguing by analogy to phone and internet. I mean, the internet is being analogized to phone and mail and other standing on the street and that sort of thing. What is the solution to that? Should we have a commission that develops technology-related regulations? Do we rely on courts to do this? I don't think so. It's hard to educate courts about the full range of technology to develop the right rules. What do you see as the solution to the pace of technology and the slower pace of regulation and congressional action?
Some of our legislative people
let me talk about net neutrality, because it's related to that.
Yes. Case in point.
No, but it actually is directly related to that. So net neutrality is one of the interesting cases where regulation is sorely needed in order to protect free expression online. And one of the reasons for that is because there's been one of the reasons for that is because the internet fundamentally is a two-sided market, right? There are gatekeepers that provide the pipes over which data flow. There are the people who produce the content, and then there are the consumers who consume the content. And because of simply because it's expensive to build networks, those networks, there's a significant amount of concentration. And so for most of us, while we may be able to get 4G on our cell phones, we may be able to get WiMAX. When it comes to actual high-speed broadband service, most markets you really only have one and at most two providers, which means that there's an economic incentive for those providers to charge additional money to the edge providers, to the content providers, to send their bits faster to the consumers. And it's one of those interesting cases where you're absolutely right. Regulation under existing law, we should be able to deal with these things through antitrust laws. But given the nature of the market and the fact that there's not a discernible antitrust harm, the only way that you actually can deal with it is by the FCC getting into the business of enforcing open internet rules. So it's an interesting case where we do actually need sort of new regulation to address kind of an old problem that's inherent to networks.
Maybe one note. Gabe spoke to net neutrality. Let me speak to tech neutrality as a principle. It seems to me that, having been part of this debate for a couple decades now, that many of the societal issues that we see arising are things that are predictable, and we see them with the dawn of a whole variety of new technologies. So, was the web, now it's the app. It will be the Internet of Things. whatever the technology is that is arising, we have a series of societal questions that are predictable. What does it mean for kids? What does it mean for sex? What does it mean for, surveillance, et cetera, et cetera? We know kind of where we want to be, and I think our constitutional principles have been really important guideposts for us. And so what I tend to prefer is, if we're going to regulate at all, then we should do it in ways that set out a series of principles that are enunciated but aren't focused at one little bit on the instant technology that's arising. When we do that, we tend to find those laws, just as the FTC enforcement regimes are obsolete before they're written, especially when Congress really doesn't do anything anymore, let's be honest. So it's even slower there than it is and I think the states sometimes exacerbate the problem. The California legislature has been particularly aggressive relative to others. And sometimes that ends up with a diversion away from laws or regulations that are focused on principles. Because I think when we articulate those principles in laws and we say, there's a series of things that we know are going to go wrong, let's make sure those don't go wrong, we're better off. Again, my solution would be here, let's decide what uses of data are inappropriate. Let's decide what uses of information we know are injurious. And then let's set up laws that prevent those things from happening, or from having people misuse the published information, whatever media it's produced in, or the data. I think that's the better approach. And then we avoid a lot of the bad stuff, but we get to capture the benefits of technologies that are arising and giving us great stuff at the same time.
The one thing, this is one thing I can say as someone who is ignorant, and that is, whatever the solution to this, and I mean, I think it's perfectly clear that government regulation does not have a Moore's law. It is continuing to plod along at a level that technology is vastly outstripping. Legislation is desperately needed. The one thing you do not want is the federal courts making these decisions. I watched the Supreme Court wrestle with these issues, and it is, we used to say pitiful where I grew up. You have a case where they're concerned about a warrant not being transmitted, and the Chief Justice says, well, maybe it's a small sheriff's department, they don't have the latest version of WordPerfect. We have a case, a very fascinating case, where the police put a GPS transmitter on a suspect's car and tracked him continuously for 28 days, and then figured out from that where his stash house was, because you can build up a tremendous pattern of people's movements over 28 days. And the Supreme Court majority decided this case based on a 1745 case in the Court of Common Pleas that held that it was a tort to nail something to your neighbor's carriage. And it's not often that I'll say these words, but I felt some sympathy for Justice Alito in that, because he writes a concurrence saying, get a horse, Grandpa. What are we doing here? Do you understand what GPS technology really is? And the answer is no, right? So the most recent thing we're waiting to hear the result of is the Worry case, and what can police do with your smartphone when you're arrested. And the whole discussion is done in terms of, is this more like a pen register, or is it like you're carrying a suitcase around? We really desperately need the kind of expertise that legislatures can call on if they happen to be feeling like doing their jobs. Because the courts really are not the place that we want this issue to be resolved. We have time for maybe one super quick question. Just a second, sir. Just a second, sir. Please wait for the microphone. Thank you.
In light of that, in terms of the courts, you still have Smith versus Maryland, and then you have two district courts that are split on the constitutionality of the NSA bulk collection program. So do you trust the Supreme Court re-examining that doctrine on the Smith versus Maryland, Gabe, or anyone else on that topic?
Sure.
Or is Congress going to step in and cure this problem before the court messes it up?
That's a great question, and it's actually so it's a great question, and it's actually a strategic question. So right now, there's legislation going through that that aims to end bulk collection and indiscriminate collection, and that could potentially impact the litigation in both Southern District and DC Circuit, the two cases that you mentioned. If the legislation doesn't go far enough, are we better leaving it up to the courts? And I'm not sure that there's necessarily a good answer. I mean, frankly, when it comes to the USA Freedom Act, which is the vehicle that would deal with bulk collection, I think folks are getting slightly more optimistic that it might improve in the Senate. It passed in a severely weakened form in the House last month, but there was just a huge outcry among privacy and civil liberties groups, including the ACLU, about the fact that it was weakened. And at the 11th hour, it passed unanimously out of both judiciary and intel, and then in rules, it was weakened. So I'm optimistic that the legislation will get better in the Senate. There's definitely an appetite to do something now, but it's a good question. And when it comes to the Supreme Court, I don't know. It's tough. Judge Leon's decision, I thought was good, and also echoes sort of the Sotomayor concurrence in U.S. v. Jones, the notion that aggregate data, even if you don't have a reasonable expectation of privacy when it's sort of one-off, the more that you get and the longer time period that you get it for, it definitely implicates reasonable expectations of privacy. I think that's the better argument, but with this Supreme Court, it's kind of a crapshoot. I'm hopeful that Congress will do something, but time will tell, and it'll happen soon.
Anybody else want a last comment on that?
Just we might have an analog. You think about, I'm thinking of a piece that Peter wrote about sort of post-Katz. We had the Wiretap Act that, so in the shadow of 5 justices on the Supreme Court and Jones suggesting that the indiscriminate collection may be something wrong with that, we might see Congress act and sort of replaying that set of circumstances from 35 years ago.
Well, with that, we will thank you all for being here, and please thank our panel. Also, please thank the ACS staff in general, and particularly Deepal, who did all the real hard work.